In this lecture, we shall discuss the different forms of invitation to treat. The different forms of invitation to treat. Now, the reason this topic is important is because in our previous lecture, we sought to draw the distinction between an offer and an invitation to treat. And in drawing the distinction, we mentioned that when a person makes an invitation to treat, it does not qualify as an offer. And the person to whom the invitation to treat is made is the one who then makes the offer. So you remember that in our previous lecture, we mentioned that for a statement to amount to an offer, then that statement must have that finality attached to it. That statement must be a statement or a communication that has that finality. It leaves nothing further for negotiation, so that the moment the party to whom it is made communicates its acceptance, then there will be deemed to be a valid contract. But we mentioned that as for invitation to treat, it is rather a communication which is not an offer. It is rather a communication that invites the party to whom it is made to make the offer. And so in this lecture, we will look at examples like display of goods in a shop. Under that topic, what we will explain is that if you enter a shop and you see goods that have been advertised with a price list attached, such an advertisement would amount to an invitation to treat and not an offer. What it means is that if anybody enters the shop and decides to see and then sees a shoe worth 500 Ghana cedis, and that person decides to go to the counter and pay the 500 Ghana cedis, it is the person who is telling the seller that he wants to buy the shoes for 500 Ghana cedis. He is the one that is rather making the offer, which the seller may or may not accept. In other words, the mere fact that you have seen a particular suit displayed with a price list attached doesn't mean that so long as you take the money to the seller is going to sell it to you. Because remember, the display of the suit in the shop with the price list attached is an invitation to treat. It is inviting the buyers to rather make the offer, which the seller may or may not accept. And over there to go and look at advertisements. Now, when a particular person advertises goods for sale, the advertisement amounts to an invitation to treat and not an offer, in that it is inviting the person to whom the advertisement is made to rather make the offer, which the seller may or may not accept. We would also look at auction sales, which means that when you attend an auction, all the people who attend the auction and make the bids, they are the people making the offers, which the auctioneer may or may not accept. And now this distinction is important because it will help you know where you stand as a buyer, to know when indeed a valid contract will be deemed to have been formed. And so to set the ball rolling, I would once again refer to the authoritative explanation of invitation to treat, according to the learned author of Treatise on Contracts, where invitation to treat was explained in the following words, and I quote, Treatise on Contracts, 28th edition, 1999, volume 1, At page 93, this is how cheating on contracts explained an invitation to treat, and I quote, a communication by which a party is invited to make an offer is called an invitation to treat. It is distinguishable from an offer primarily on the ground that it is not made with the intention that it is to become binding as soon as the person to whom it is addressed simply communicates his assent to its terms. End of quote. I'll take the quote once again. A communication by which a party is invited to make an offer is commonly called an invitation to treat. It is distinguishable from an offer primarily on the ground that it is not made with the intention that it is to become binding as soon as the person to whom it is addressed simply communicates his assent to its terms. End of quote. So what we are saying over is that, for example, the advertisement of goods, it is not made with the intention that it is to become binding as soon as the person to whom the advertisement is made communicates his acceptance. A display of goods in a shop, the display is not made with the intention that it is to become binding as soon as the person to whom it is addressed simply communicates his assent. So for an invitation to treat, it is the one that is rather inviting the other party to make the offer. And the person who is making the advertisement may or may not accept the offer. And so the different kinds of invitation to treat we shall look at in this lecture are display of goods in a shop, auction sales, tenders, advertisement of goods or services in a newspaper, circulation of catalogs or price lists. So we shall begin with the first, display of goods in the shop. And over here, we will refer to the authoritative case of Fisher and Bell. Fisher and Bell. This case is so important that you cannot be a good student of law of contracts and say you're not aware of the case of Fisher and Bell. Fisher, Fisher versus Bell, Bell, reported in 1961, 1 Queen's Bench at page 394. Now, the facts and holding I shall read on from this case are not taken from the actual reports, but are taken from the authoritative case book by Geopool on Contract Law, 13th edition. So these are the brief facts of Fisher and Bell, taken from Geopool's case book on contract law, and I quote, a shopkeeper displayed a flake knife in his shop window with a ticket stating ejector knife and the price attached. He was charged with offering the knife for sale contrary to Section 11 of the Restriction of Weapons Act 1959. Now let me explain the facts before I move on. There is a law that says that nobody is supposed to offer for sale a particular knife. Nobody is supposed to offer this particular knife for sale. And then now a shopkeeper has been found displaying this particular flake knife in the shop window with a price attached. For example, the government of Ghana decides to ban the sale of tramadol. Then he sees one person's shop where the tramadol has been displayed with a price attached. Similar facts as what we have over here. A shopkeeper has displayed a flake knife in a shop window with a ticket stating ejector knife and a price attached. Now he has been charged with offering the knife for sale contrary to section 1 subsection 1 of the Restriction of Weapons Act of 1959. So the question would be whether the display of the flake knife in the shop, whether it amounts to an offer or an invitation to treat. If the court finds that the display of the flake knife amounts to an offer, then it means that the shopkeeper is going to be held liable for having breached the law. But if it is found that the display of the flake knife with the price attached amounts to an invitation to treat, then it means the shopkeeper has not flouted any law, because it is the buyer who rather make the offer, which the shopkeeper may or may not accept. So once again, the facts are that, and we are referring to the case of Fisher and Bell, reported in 1961, 1 Queen's Bench at page 394. The facts are that a shopkeeper displayed a flake knife in a shop window, with a ticket stating ejector knife and then the price attached. He was charged with offering the knife for sale, contrary to section 1, subsection 1 of the Restriction of Offensive Weapons Act of 1959. And what did the court hold? It was held that a display of goods in a shop window with a price ticket attached was merely an invitation to treat and not an offer, so that no offense had been committed. So that no offense had been committed. So it's been found in this case of Fisher and Bell that when a person displays goods with a price list attached in a shop window, the display of goods in the shop does not amount to a contractual offer, but it rather amounts to an invitation to treat. If you forget any case in contract law, Fisher and Bell, you cannot afford to forget it. There's another case that also makes it very clear as far as the display of goods in a shop is concerned, and it's a case of Pharmaceutical Society of Great Britain. Pharmaceutical Society of Great Britain versus Boots Cash Chemists. Boots is spelled B-O-O-T-S, Cash, C-A-S-H, Chemists. Reported in 1953, 1 Queen's Bench at page 401. Pharmaceutical Society of Great Britain versus Boots Cash Chemists. Reported in 1953, 1 Queen's Bench at page 401. And these are the facts and holding that are taken from Geopoole's casebook on contract law, 13th edition. Remember, we are referring to Pharmaceutical Society of Great Britain versus Boots Cash Chemists, and we'll use this case to also demonstrate that the display of goods in a shop with prices attached does not amount to an offer, but rather amounts to an invitation to treat. Pharmaceutical Society of Great Britain versus Boots Cash Chemists. And these are the brief facts taken from Geopoole's casebook on contract law. The brief facts. Boots was charged with an offense under the Pharmacy and Poisons Act of 1933, section 18, which required that sales of poisons in part 1 of the poisons list take place under the supervision of a registered pharmacist. Boots operated a self-service system, and a pharmacist at the cash desk was authorized to prevent the removal of any drug from the premises. The factor determining whether an offense had been committed was the point at which the sale in this self-service shop would begin to have taken place. Now let me explain this fact to you. There is a law that says that sale of poisons in part 1 of the poisons list must take place under the supervision of a registered pharmacist. Now, these people in this case, Boots, they operate a self-service system. And the pharmacist in this case was at the cash desk. And his role was to prevent removal of any drug from the premises. So the question will be, the law says that you are not supposed to offer these drugs for sale unless there's the supervision of a registered pharmacist. Now, if the sale must be done under the supervision of a registered pharmacist, if I take the poison from the shelf and I'm walking with it to the counter, would the sale be deemed to have been concluded? If the sale be deemed to have been concluded, then it means that the boost cash people have violated the law. But let us see what the law says, what was held. It was held that a display of goods in a shop window with a price ticket attached was merely an invitation to treat and not an offer for sale, so that no offense had been committed. A display of goods in a shop window with a price ticket attached was merely an invitation to treat and not an offer for sale, so that no offense had been committed. And now let me quote specifically from what the learned justice, Lord Goddard CJ, said. And his statement is so important that the moment you listen to his statement, any doubt you have in your mind about display of goods in a shop amounting to an invitation to treat would have been cleared. This is what Lord Goddard CJ said, and I quote. So I'm quoting Lord Goddard CJ in this case of Pharmaceutical Society of Great Britain versus Boots Cash Chemists. Quoted in 1953, 1 Queen's Bench at page 401. This is what the learned justice said, and I quote. I think that it is a well-established principle that the mere exposure of goods for sale by a shopkeeper indicates to the public that he is willing to treat but does not amount to an offer to sell. I'll take that portion again. I think that it is a well-established principle that a mere exposure of goods for sale by a shopkeeper indicates to the public that he is willing to treat but does not amount to an offer to sell. I do not think I ought to hold that that principle is completely reversed merely because there is a self-service scheme such as this in operation. In my opinion, it comes to no more than that the customer is informed that he may himself pick up an article and bring it to the shopkeeper with a view to buying it. But only if the shopkeeper then expresses his willingness to sell, the contract is completed. Let me take that portion again. In my opinion, it comes to no more than that the customer is informed that he may himself pick up the article and bring it to the shopkeeper with a view to buying it. And if, but only if the shopkeeper then expresses his willingness to sell, the contract for sale is completed. In fact, the offer is an offer to buy, and there's no offer to sell. The customer brings the goods to the shopkeeper to see whether he will sell or not. Let me explain this portion before I move ahead. Now, what Lord Goddard CJ is saying is that when you, the customer, you pick up the item and you get to the counter, you are rather making the offer to buy. And then the offer to buy may or may not be accepted by the seller. So it is only when you take the item from the shelf, you walk to the counter and you make the offer to buy. It is only when the seller accepts it that a contract will be deemed to have come into existence. But if you take it to the counter, the seller may refuse to sell it and that's why you don't have anything to do. You cannot do FOCO if you take an item from a shelf, you get to the counter, and the seller refuses to sell to you. You cannot do anything about it. You must go back, put it down, and go home, because you have made an offer to buy, and the seller has declined that particular offer. So what Brother CJ says as follows: that, in my opinion, it comes to no more than that the customer is informed that he may himself pick up an article and bring it to the shopkeeper with a view to buying it. And if, but only if, the shopkeeper then expresses his willingness to sell, the contract for sale is completed. In fact, the offer is an offer to buy, and there's no offer to sell. The customer brings the goods to the shopkeeper to see whether he will sell or not. In 99 cases out of 100, he will sell. And if so, he accepts the customer's offer, but he need not do so. The very fact that the supervising pharmacist is at a place where the money has to be paid is an indication to the purchaser that the shopkeeper may not be willing to complete a contract with anybody who may bring the goods to him. I agree with the illustration put forward during the case of a person who might go into a shop where books are displayed. In most bookshops, customers are invited to go in and pick up books and look at them, even if they do not actually buy them. There is no contract by the shopkeeper to sell until the customer has taken the book to the shopkeeper or his assistant and said, "I want to buy this book." And the shopkeeper says yes. Let me take that portion again. And these are the words of Lord Goddard CJ. And the case in point is Pharmaceutical Society of Great Britain versus Boots Cash Chemists. And I'm quoting Lord Goddard CJ. There is no contract by the shopkeeper to sell until the customer has taken the book to the shopkeeper or his assistant and said, "I want to buy this book." And the shopkeeper says yes. That would not prevent the shopkeeper seeing the book picked up saying, "I'm sorry, I cannot let you have that book. It is the only copy I have got, and I have already promised it to another customer." Therefore, in my opinion, the mere fact that a customer picks up a bottle of medicine from the shelves in this case does not amount to an acceptance of an offer to sell. It is an offer by the customer to buy, and there is no sale effected until the buyer's offer to buy is accepted by the acceptance of the price. The offer, the acceptance of the price, and therefore the sale take place under the supervision of the pharmacist. End of quotes. So what have we seen in this case of Pharmaceutical Society of Great Britain versus Boots Cash Chemists? We are told in this case that the display of goods in a shop does not amount to an offer to sell, but rather it is an invitation to treat. It is inviting the customers who enter the shop to either make the offer to buy, which the seller may or may not accept. And so this case of Pharmaceutical Society of Great Britain versus Boots Cash Chemists is in line with the case of Fisher and Bell, all holding that the display of goods in a shop with price list attached does not amount to an offer, but rather amounts to an invitation to treat. And it's the buyers who make the offer, which the seller may or may not accept. So we are done with the first form of invitation to treat, i.e., the display of goods in the shop. The next form of invitation to treat we shall look at are advertisements. Now, the general rule is that when people advertise in a newspaper, particular product. The advertisement in the newspaper is an invitation to treat and not an offer. And so a newspaper advertisement of a particular product is not an offer, but rather it's an invitation to treat. It is inviting the people to whom the advertisement is made to rather come and make the offer. And over here, I refer you to the case of Partridge versus Crittenden. Partridge versus Crittenden. Now, what are the brief facts of this case? The plaintiff in this case placed an advertisement in a periodical. The advertisement was in essence advertising a particular bird for sale. And then he was charged with the offense of offering for sale a wild live bird, contrary to the Protection of Birds Act of 1954. So there was an act in question that had criminalized the offering of such birds for sale. Now the act has criminalized offering this bird for sale, and you have gone to advertise that this bird is being sold. It was held by Lord Parker that the advertisement of the particular bird was not an offer for sale, but was only an invitation to treat. And therefore, the person in this case could not be held liable for the offense charged. That is the case of Partridge versus Crittenden. Partridge versus Crittenden. So you've seen the second form of invitation to treat, you've seen advertisement, which also say that an advertisement of goods does not amount to an offer, but rather amounts to an invitation to treat. So remember the case of Fisher and Bell, and then Pharmaceutical Society of Great Britain versus Bootcast Chemists. Those two cases relate to display of goods in a shop window with a price list attached. That those display of goods in a shop window do not amount to an offer, but they rather amount to an invitation to treat. And now you look at advertisements, Partridge and Crittenden. Now, advertising goods for sale too will not amount to an offer, but will only amount to an invitation to treat. But one caution I have to give is that even though we have held that in Partridge and Crittenden, an advertisement for goods amount to an invitation to treat and not an offer, there are some cases in the law where an advertisement may be interpreted as an offer and not an invitation to treat. In other words, even though we have seen in Partridge and Crittenden that an advertisement is an invitation to treat and not an offer, I'm saying that by the authorities, there are some cases whereby an advertisement can amount to an offer and not an invitation to treat. The clearest case that can demonstrate this is the case of Carlyle versus Carbolic Smoke Ball. Carlyle versus Carbolic Smoke Ball. Carlyle is spelled C-A-R-L-I-L-L. Carlyle versus Carbolic. C-A-R-B-O-L-I-C. Smoke Ball. Carlyle versus Carbolic Smoke Ball Company Limited. Reported in 1893. 1 Queen's Bench at page 256. Now, the facts of this case are that the defendants in this case, that is the Carbolic Smoke Ball Company Limited, they made and sold a particular medical preparation. And the name of this medical preparation was the Carbolic Smoke Ball. The defendants made and sold a medical preparation called the Carbolic Smoke Ball. Now, they, that is the defendants in this case, the advertisement was conveyed in the newspaper with the following words. I'm going to quote the words of the advertisement so that you can understand why the court in this case would hold that the advertisement in this case would not amount to an invitation to treat, but rather be an offer. These are the words of the advert, and I quote: £100 sterling reward will be paid by the Carbolic Smoke Ball Company to any person who contracts the increasing epidemic influenza, colds, or any disease caused by taking code after having used the ball 3 times daily for 2 weeks, according to the printed directions supplied with each ball. £1,000 is deposited with Alliance Bank, Regent Street, showing our interest in the matter. Now, at this point, you realize that the smoke ball company is saying that we have manufactured this particular smoke ball, and we are saying that whoever will use this smoke ball according to our instructions, and then will contract the increasing epidemic influenza caused any other disease, we shall give you an amount of money, £100. So they have made the advertisement, and all they are requiring is that anybody should go and buy the smoke ball, use it according to the instructions, and if you get influenza, you are going to be paid an amount of money. Now, the question in this case is that the display of these goods, and led one person to rely on advertisements. So the plaintiff in this case, that is Khalil, he relied on advertisement, purchased one of the smoke balls at a chemist. He used it in compliance with advertisement, and lo and behold, he contracted the influenza. And he sued the defendant, the Carbonic Smoke Ball Company Limited, for the £100, but the defendants refused to pay. One question for the court to decide was whether the advertisement in this case, whether it was an offer or an invitation to treat. Whether it was an offer or an invitation to treat. And we are referring to the case of Khalil versus Carbolic Smoke Ball Company Limited. The brief facts of this case are that the defendant company manufactured a particular medical preparation. They advertise that whoever will take this medical preparation, buy it, use it according to the instructions, and contract the influenza, he shall be paid an amount of money. The plaintiff in this case bought a medical preparation, used it according to the instructions, contracted the influenza, and has sued the defendant for the money, but the defendants have refused to pay. The question was whether the advertisements amounted to an offer or an invitation to treat. Now, the court in this case held that the advertisement in this case did amount to an offer. And for the reason why the court took this particular conclusion, we shall refer to the words of the learned justice Lindley LG, and this is what the learned justice said. And the case in point is Khalil versus Carbonic Smoke Ball Company Limited. And these are the words of the judge, and I quote. Now that point is common to the word of this advertisement and to the word of all other advertisements offering rewards. They are offers to anybody who performs the conditions named in the advertisement, and anybody who does perform the conditions accept the offer. In point of law, this advertisement is an offer to pay £100 to anybody who will perform these conditions, and the performance of the conditions is the acceptance of the offer. I'll take that portion once again. In point of law, this advertisement is an offer to pay £100 to anybody who will perform these conditions. And the performance of these conditions is the acceptance of the offer. And so that was what was held in this case. Lindley added what I had to say as follows. That supposing that the performance of the conditions is the acceptance of the offer, that acceptance ought to have been notified. Unquestionably, as a general proposition, when an offer is made, it is necessary in order to make a binding contract, not only that it should be accepted, but that the acceptance should be notified. But is that so in cases of this kind? I think the true view in a case of this kind is that the person who makes the offer shows by his language and from the nature of the transaction that he does not expect and does not require notice of the acceptance apart from notice of the performance. Now, for those of you who are losing track of the facts, the brief fact of this case of Khalil versus Carbonic Smoke Ball Company Limited is that the defendants manufacture a medical preparation called the carbonic smoke ball. They advertise that whoever shall use the smoke ball according to the instructions and contract the influenza, cold, or any other disease, we shall pay you £100. The plaintiff bought the medical preparation, uses according to the instructions, and has contracted the influenza. He has sued for the money. The defendants were saying that the advertisement did not amount to an offer. The court said that no, the way this advertisement was couched, it was requiring the performance of a specific act. And the performance of that specific act is what will amount to acceptance. Then one argument was raised that, okay, by in law too, if you accept, why did you notify the company? The court says that if you make this kind of contract, where you say that whoever shall do this, we shall pay this amount of money. By saying that whoever shall do this one, you yourself, you are waiving your right to receive notice of acceptance. Because by a contract, they are saying that all that you require is that there must be the performance. So, for example, examples would be reward contracts. You are looking for a particular armed robber. You say that whoever shall arrest this armed robber, we shall pay you 100,000 cedis. I don't have to notify you that I'm going to arrest the armed robber. All I need to do is to go and look for him. As soon as I perform the act of arresting him, you must pay me my 100,000 cedis. That is the example of fact that you have in Khalil versus Carbonic Smoke Ball Company Limited. So all the examples you see about reward contract, police saying that they are looking for this criminal, whoever can help them arrest, we pay this amount. That statement amounts to an offer to the whole world. And so whoever goes ahead to arrest the criminal will be deemed to have accepted the offer. And so he can sue for the payment of the money. So in this case of Khalil versus Carbonic Smoke Ball Company Limited, we are being told that an advertisement can also be construed as an offer, especially when the advertisement qualifies as what we can call a general offer, an offer being made to the whole world, which is only requiring the performance of an act as an acceptance. In that case, whoever goes to perform the act will be deemed to have accepted the offer. And that's why Lindley Elder says that now the point is common to the words of this advertisement and to the words of all other advertisements offering rewards. They are offers to anybody who performs the conditions named in the advertisement. And anybody who does perform the conditions accepts the offer. In point of law, this advertisement is an offer to pay £100 to anybody who will perform these conditions. And the performance of the conditions is the acceptance of the offer. This is the case of Khalil versus Carbonic Smoke Ball Company Limited, and the judge is Lindley LG. Now remember, we had to look at this case because we mentioned in Patrick and Crittenden that an advertisement amounts to an invitation to treat. And we use this case of Khalil and Carbonic Smoke Ball to demonstrate that it is not in every case that an advertisement will amount to an invitation to treat. And as we've seen in Khalil and Carbonic Smoke Ball Company, the advertisement to pay £100 to anybody who will use the smoke ball was construed as an offer and not an invitation to treat. Now, another case that demonstrates that an advertisement can also be deemed to be an invitation to treat is the case of Lefkowitz versus Great Minneapolis Surplus Stores. Lefkowitz is spelled Lefkowitz. Lefkowitz versus Great Minneapolis Surplus Stores. This case also demonstrates that there are times when an advertisement can also be construed to be an offer and not an invitation to treat. The facts of this case are quite interesting. There were 3 fair quotes that were advertised in a newspaper with the following words: Saturday 9 a.m. sharp, 3 brand new fair quotes worth $100. First come, first served, $1 each. Again, 3 fair quotes were advertised in a newspaper with the following words: Saturday 9 a.m. sharp, 3 brand new fair quotes worth $100. First come, first served, $1 each. Saturday 9 a.m. sharp, 3 brand new fair quotes worth $100. First come, first served, $1 each. The plaintiff showed up first at 9 a.m., but the defendant refused to sell to plaintiff. So you see, you've advertised in your newspaper, Saturday 9 a.m. sharp, 3 brand new fair quotes worth $100. First come, first serve, $1 each. And you said first come, first serve. The defendant showed up first at 9 a.m. And when he came, you refused to sell to the plaintiff. Plaintiff sued, they said, my friend, whatever you advertise, insofar as you said first come, first serve, even though it's an advertisement, in law, it's supposed to amount to an offer. So since I came there first, my coming there first is supposed to be deemed to be an acceptance, and say must sell to me. What did the court hold? The Supreme Court of Minnesota held that the advertisement in this case amounted to an offer and not an invitation to treat. This is because there was no restriction of the advertisement to only women, which was made clear from the advertisement. The defendants did not have the right to limit their right to only women after the plaintiff has showed up. So we've seen in this case of Lefkowitz versus Great Minneapolis Surplus Stores that if you advertise and the scope of the advertisement is very clear, it leaves nothing further for negotiation. Like we've seen in Lefkowitz versus Great Minneapolis Stores, your advertisement will be construed as an offer and not an invitation to treat. That is Lefkowitz and Great Minneapolis Stores. So at this point, what you must bear in mind is that we have referred to the case of Partridge and Crittenden. Remember, we are discussing the different forms of invitation to treat. We've already dealt with display of goods in a shop, where we dealt with the case of Fisher and Bell and Pharmaceutical Society of Great Britain versus Boots Cash Chemists. And these 2 cases, you must remember them. They demonstrate that when you display goods in a shop with price list attached, they amount to an invitation to treat and not an offer. Then we went to advertisement, where we refer to the case of Partridge and Crittenden. And over there, we mentioned that an advertisement of goods would not amount to an offer, but only amount to an invitation to treat. That's Partridge and Crittenden. And from this case, we mentioned that even though this case says that an advertisement of goods amounts to an advertisement, amounts to an invitation to treat and not an offer, we mentioned that there are times when an advertisement can amount to an offer. And an example we saw was the case of Carleo versus Carbolic Smoke Ball Company Limited. And this case demonstrates that when you advertise and you tell the whole world that whoever will do this, you shall pay the person this amount of money, your advertisement will be construed to be a general offer. It will be deemed to be a unilateral offer to the whole world. And whoever shall perform the act that you prescribed will be deemed to have accepted your offer, and you must pay the person. So Carleo and Carbolic Small Ball demonstrates that even though we've seen in Partridge and Crittenden that an advertisement is supposed to be an invitation to treat, there are times when an advertisement can rather be construed to be an offer, as we've seen in Carleo versus Carbolic Small Ball Company Limited. And another case we used to buttress that was the case of Lefkowitz versus Great Minneapolis Surplus Stores, where you advertise 3 fair quotes. You say Saturday 9 a.m. sharp, first come, first served. The first come, first serve means that you are making an offer to whoever will come there first. And so we've seen Patrick and Crittenden, Carlisle and Carbonic Small Ball Company, and the Lefkowitz versus Great Minneapolis Surplus Stores. So we are done with two forms of invitation to treat. We are done with display of goods, and we are done with advertisements. The next example we shall look at as far as invitation to treat is concerned is tender notices. Tender notices. Sometimes somebody wants to sell a particular product, or you want to buy a particular product, and you invite tenders. So people will submit their tenders that I can supply you with this at this price. I can supply you with this at this price. You want air conditioners, you've invited tenders. People are giving tenders. Then I can supply you with this at this price. So you get tenders from 10 people. One person says, I can give you 100 air conditioners at 100 Ghana cedis each. Another person says, I can give you 100 air conditioners at 20 Ghana cedis each. Another person says, I can give you 100 air conditioners at 5 Ghana cedis each. Now, what does the law say about this? Can the person who supplied the best tender be deemed to be the one that has won the contract? Or if you publish the tender notice, the people who submit the tenders, are they the ones making the offer? Let's see what the law says. The general rule, emphasis general rule. The general rule is that when a person invites tenders for a specified project, such an invitation to tender is an invitation to treat and not an offer. The offer is rather made by the person who submits the tender. The offer is rather made by the person who submits the tender. And the acceptance takes place when the person who invites the tenders accepts one of the tenders. In appropriate cases, the court may hold that an invitation to tender may be an offer. But the general rule is that where a person invites tenders for a specified project, the invitation is an invitation to treat. And the people who submit the tenders are the ones who rather make the offer. The clearest case that demonstrates this principle is the case of Spencer versus Hardin. Spencer versus Hardin, reported in 1870. And these are the facts of the case. A circular was sent out by defendants, indicating that the defendants had been instructed to offer for sale certain goods by tender. The circular gave the time and date that the tenders will be received. The plaintiff submitted the highest bid, but the defendants refused to sell to them. The plaintiff thereupon sued, alleging that the circular was an offer to sell the goods to the highest bidder, and since that day the plaintiff had submitted the highest bid, the defendants were bound to sell to them. Think about it. Circular sent out by defendants saying that they have been instructed to sell some things by tender. So everybody gives their tender about how much they are ready to buy it for. The plaintiff in this case was the one who submitted the highest tender, but the defendants still refused to sell to them. So plaintiff sued and said that, but if you have invited to sell goods by tender, that tender that you invited was an offer. So since I was the highest person who submitted the tender, you must sell to me by force. What did the court hold? Now, the court held in this case that in advertisements for tenders, for buildings, it is not usual to say that the contract will be given to the lowest bidder. And it's not always that the contract is made with the lowest bidder. And here there's a total absence of anywhere to intimate that the highest bidder is to be the purchaser. It is a mere attempt to ascertain whether an offer can be obtained within such a margin that the sellers are willing to adopt. So the court in this case construed the invitation to sell by tender as an invitation to treat, and the people who were submitting the bids were the ones making the offers. So Spencer and Harding is an indication that when you invite people to come in, you want to sell things by tender, the people who submit the bids are the ones that are making the offers, which may or may not be accepted by the person inviting the tender. Now, that is the case of Spencer and Harding. But remember, I gave a caution that even though I said that invitation to sell goods by tender, it's an invitation to treat. Remember, I cautioned that in appropriate cases, the court may hold that an invitation to tender was in fact an offer. So, if you are inviting tenders, but you give an express statement that whoever shall submit the highest bid, you shall sell to the person, then that's one. Your statement can be construed to be an offer. And so let us look at the case of Havela. Havela Investments Limited versus Royal Trust Company of Canada Limited. Havela Investment Limited versus Royal Trust Company of Canada Limited. Now, this was a case in which goods were advertised. And let me read the facts to you. The first defendant opted to sell their shares by a sealed competitive tender. They then invited the two parties who were most likely to be interested in the shares to each submit a single sealed offer for their shares. The defendants stated in their invitation that they would accept the highest offer. So take note, they have stated in their invitation that they will accept the highest offer. Received by them, and we shall comply with the terms of the invitation. The claimants tendered a fixed bid of $2,175,000. On the other hand, the second defendant tendered a referential bid of $2,100,000, or $101,000 in excess of any other offer, whichever is the higher. The first defendant accepted the second defendant's bid, treating it as $2,276,000 United States dollars. Now let me explain the facts over here. The first defendants are opting to sell their shares by sealed competitive tender, and then they have invited the two parties who were most likely to be interested to each submit a single sealed offer for their shares. And they have mentioned that whoever shall submit the highest offer, that one we shall sell to that particular person. Now, claimants tendered a fixed bid of $2,175,000. But the second defendant tendered a referential bid of $2,100,000. It means that this is lower than the other one of $2,175,000. So the claimant is the one who tendered for the $2,175,000. Second defendant tendered a referential bid of $2,100,000. So that one is lower. But the second defendant was trying to be smart. So even though he made a bid for $2,100,000, he added or $101,000 in excess of any other offer. So he's trying to play $2,100,000 or an additional $101,000. And that is the one rather that was accepted by the first defendant. So the claimant sued and said that, my friend, I made a bid for $2,175,000. The other person made a bid of $2,100,000. Forget about that, or $101,000 in excess. Forget about that one. If you look at the two figures that we all mentioned, I mentioned $2,175,000. He mentioned $2,100,000. Mine is higher than his, so I was the one supposed to sell to. Now, what did the court hold? It was held in this case that the first defendants were bound to accept the claimant's bid. And in this case, the invitation to tender was construed as an offer of a unilateral contract to sell the shares to the highest bidder. It is important to note that the invitation to tender was construed as an offer, even though the invitation actually asked the claimants and the second defendant to submit an offer. With respect to the bid made by the second defendant, it was held to be invalid because the object of the invitation made by the vendors was to ascertain the highest amount which each party was prepared to pay. And that purpose will be defeated by the referential bid. And therefore, in this case of Havela, we are being told that the court construed the invitation to sell by tender. That invitation that was accompanied by express words, express undertaking to accept the highest bid. The court construed that invitation to be an offer and not an invitation to treat. Havela Investments Limited versus Royal Trust Company of Canada Company Limited. It means that even though we have seen in the case of Spencer and Hardin that invitation to sell by tender will be an invitation to treat, when the invitation to sell by tender is accompanied by express words that you will sell to the person who makes the highest bid, as we have seen in Havela Investment Limited versus Royal Trust Company of Canada, the invitation will be construed as an offer and not an invitation to treat. So just like we saw for advertisement, you remember for advertisement, we saw Patrick and Crittenden, where we saw that if you advertise goods, the advertisement will be construed to be an invitation to treat and not an offer. You remember Patrick and Crittenden, where we took that particular position. Now, even though we took that position in Patrick and Crittenden, we were quick to come and intervene and mention that even though generally advertisements are invitation to treat, you remember when we looked at Cologne and Carbonic Smoke Ball Company, where even though we had an advertisement, it was construed to be an offer. And we also look at the case of Lefkowitz versus Great Minneapolis Stores, first come, first served, that even though it was an advertisement, the words that accompanied the advertisement made the court construe that advertisement as an offer. So in that same way too for tender notices, you remember in tender notices too, we saw in Spencer and Hardin that an invitation to sell goods by tender will be deemed to be an invitation to treat. You remember Spencer and Hardin? Now we've also added that even though an invitation to sell goods by tender is an invitation to treat, remember, we've added that when the invitation to sell by tender is accompanied by an expert undertaking that you will accept the highest bid, then that one, the court may construe it to be an offer and not an invitation to treat. And the authority to buttress that is the case of Havela Investments Limited versus Royal Trust Company of Canada. So we've looked at three forms of invitation to treat so far. We have looked at display of goods for sale, where we look at Fisher and Bell, Pharmaceutical Society of Great Britain versus Booscast Chemists. We've looked at advertisements for goods of services in the newspaper, where we've seen Patrick and Crittenden. We've seen Khalil and Carbonic Smoke Ball Company. And we've seen Lefkowitz versus Great Minneapolis stores. We've dealt with tenders, where we said that an invitation to sell goods by tender is supposed to be an invitation to treat, generally, and not an offer. And over there, we look at Spencer and Harding. But we mentioned that if it is accompanied by express words, if the invitation to sell by tender is accompanied by express words that you shall sell to the highest bidder, then that's when the invitation will be construed to be an offer. Now, let us now go to auction sales. Auction sales. Auction sales. Now, the general rule is that where an auctioneer invites bids to be made at an auction, the offer is not made by the auctioneer, but rather the offer is made by the person who is making the bid. When the bid is made, it is accepted by the auctioneer by the striking of the table with his hammer. Now, what does this principle mean? It means that if it has been advertised that goods are being sold by auction, when you attend the auction, you who say that 10,000, 20,000, 30,000, 40,000, all of you who are making this bid, 100,000, going, 50,000 is good, all of you making the bids, you are the one making the offer. And the auctioneer may or may not accept this offer you are all making. So the invitation to sell by auction is an invitation to treat. The invitation by the auctioneer that is submitting is inviting bids. That one is an invitation to treat. And the people who mention 10,000, 20,000, 30,000, 40,000, 50,000, going, 100,000, going, 200. All of the people mentioning this bid are the ones making the offers, which may or may not be accepted by the auctioneer. And it is when the auctioneer strikes the table with the hammer, that is when he will say that he has not accepted a particular offer that has been made. And the authority for this is the case of Harrison versus Nickerson. Harrison versus Nickerson. Remember, the principle is that an invitation to make bids as an auction is an invitation to treat and not an offer. And the authority is Harrison versus Nickerson, reported in 1873 LR 8 or Queen's Bench at page 286. What are the facts of this case? The facts are that the defendant, who was an auctioneer, placed an advertisement in the London papers indicating that certain materials, including some office furniture and plants, would be sold by him, the auctioneer, at a particular place on specified days. So the defendant and auctioneer placed an advertisement in the London papers indicating that certain materials, including some office furniture and plants, would be sold by him at a particular place on specified days. The plaintiff, who had a commission to purchase the furniture, traveled from London for the sale. However, when he went to the place indicated in the advert, he was able to purchase certain lots apart from the goods that have been described as office furniture in the advert, which had been withdrawn and were not put up for sale. The plaintiff then instituted the action against the defendant to recover for his loss of time and expenses. Let me explain what is happening here. You, the defendant and auctioneer, you are going to place an advert in the London papers that certain materials, including some furniture, you mentioned furniture, nobody sent you. You mentioned office furniture, will be sold by you at a particular place. Then you allow the plaintiff to travel from far and then come to the designated place, only for him to get there, and then that furniture that you advertise, you have withdrawn it. He said you will sell it again. Plaintiff was so angry, then sued and said that, my friend, you must pay me for all the loss of time and expenses. So the question then will be, the invitation to come and make a bid, can it be construed to be an offer to you or to be an invitation to treat? If it's an invitation to treat, it means that when you go there, you are going to make the offer, which may or may not be well accepted. If you are the one going to make the offer, then why do you even go and sue him? So let us see how the court will construe the invitation to people to make bid at an auction. Whether the court will construe it to be an offer or an invitation to treat. The court held in this case that, I remember I referring to the case of Harrison versus Nickerson, that advertisement to inviting the bids at the auction was not a contractual offer, but was merely an invitation to treat. Therefore, the advertisement did not amount to a promise by the auctioneer that all of the articles advertised would be put up for sale. Again, the advertisement was not a contractual offer, but was only an invitation to treat. Therefore, the advertisement did not amount to a promise by the auctioneer that all of the articles advertised will be put up for sale. The defendant was therefore not liable in damages. So you see, this case of Harrison and Nickerson is telling us that when goods are advertised to be sold by auction, the advertisement amounts to an invitation to treat. And it's the people who attend the auction who make the bids. They are the ones who are make the offers, which may or may not be accepted by the auctioneer. So in this case, where you traveled from far and then you went, and the goods that you wanted to buy had been withdrawn, you cannot do focal about it because the invitation that you should come and make the bids, that invitation was an invitation to treat and not an offer. And that when you go, you are the one going to make the offer. And the offer, even when you make it, he may even refuse to accept it. So if he has withdrawn it, how do you complain? So the court held that the defendant was not liable in damages. So remember that as far as auction sales are concerned, according to Harrison and Nickerson, then an invitation to persons that you want to sell goods by auction, it is supposed to be deemed to be an invitation to treat and not a contractual offer. Now remember that auction sales can either be an auction sale subject to a reserve price or the one without a reserve price. Now let me deal with the auction sale without reserve price. Now when you attend an auction and the auction is advertised as without reserve price, what does it mean? It means that the vendor shall be ready to sell the goods to whoever shall be the highest bidder, regardless of what the price of such a bid is. So if you advertise selling your vehicle by auction to the highest bidder, if I make a bid of 1 Ghana cedi and no other person makes any other bid, and the time is over, I'm the one that you have sold the car to for 1 Ghana cedi. Don't even complain, because nobody sent you to advertise your auction sales without reserve price. If it is without reserve price, then it means that you, the person offering the property, you, the person advertising the property as an auction sale, you are ready to sell to whoever shall be the highest bidder, whether you like the price or you don't like it. So if it's your house at East Legon in the Greater Accra region of the Republic of Ghana, very, very luxurious area, and you say that you are auctioning your house without reserve price, if I make a bid of 10 Ghana cedi, and then no other person makes any other bid, you must sell your house to me at 10 Ghana cedi. We don't care whether the house is worth $1 million or not. You must sell this to me at that price. That is auction sale without reserve price. And take note, and do not forget this warning. If I make the bid of your house for 10 Ghana cedi, the owner cannot come and say that he's bidding 100,000 cedis so that he will spoil my bid. When you advertise without reserve price, the owner or his agent cannot make a bid at the auction sale. And the auctioneer too cannot knowingly accept a bid from a person knowing that that person too is the owner of the property. And the case that you would like so much that demonstrates this is the case of Wallow versus Harrison. Look at the year. As far back as in 1859, Wallow and Harrison. This is what happened in that case. The defendant, an auctioneer, advertised the sale of a horse by auction. He stated in the notice that the sale would be without reserve price. The plaintiff attended the sale and made a single bid of 60 guineas for the horse. The horse's owner, Henderson, bid 61 guineas for the same horse. Look at what is happening here. You have advertised without reserve price, and the plaintiff had made bid a bid of 60 guineas. Then the horse's owner, the owner, Henderson, he bid 61 guineas for the same horse. Then the defendant auctioneer then knocked down the horse to the said Henderson, who was the owner of the horse. How do you do that? When you have said that the thing is without reserve price, I've come to bid 60 guineas because you don't like the price, so you also come to bid 61, so that is for my bid. And the auctioneer too has given the product to the owner of the horse. The plaintiff then sued, claiming that the horse was for he, the plaintiff, because he was the highest bona fide or genuine purchaser as an unreserved sale. He said that he was the one who made the highest bona fide, good faith, and genuine bid. So he's the one that they're supposed to give it to. And the court agreed with him that because the sale was advertised without a reserve price, then it came with a promise that you sell to whoever was the highest bona fide bidder. And the highest bona fide bidder in this case was the plaintiff because he made a single bid of 60 guineas. The other person who made the 61 guineas, he didn't make it in good faith because he's the owner. And the law prohibits owners from making the bids whenever they advertise the sale as without reserve price. So let me take the fact again, then I'll take you to the holding. The defendant, an auctioneer, advertised the sale of a horse by auction, and he stated in the notice that the sale would be without reserve price. The plaintiff attended the sale and made a single bid of 60 guineas for the horse. The horse's owner, Henderson, bid 61 guineas for the same horse. The defendant auctioneer knocked down the horse to the said Henderson, who was the owner, for 61 guineas. The plaintiff sued, claiming that the horse was for the plaintiff since he was the highest bona fide purchaser at an unreserved sale. It was held that the advertisement without reserve price came with the second promise that you sell to the highest bona fide purchaser. So it was supposed to go to the plaintiff. But let me quote the express words of the judge so that you can get the import very well. It is so important that I must quote in extenso the dictum of the judge so that you can appreciate it very well. Wallow and Harrison, and we are quoting the dictum of Martin B. And I'm quoting: the sale was announced to be without reserve. This, according to all the cases, both at law and equity, means that neither the vendor nor any person in his behalf shall bid at the auction, and that the property shall be sold to the highest bidder, whether the sum bid be equivalent to the real value or not. We think the auctioneer who puts up the property up for sale, upon such a condition, pledges himself that the sale shall be without reserve. Or in other words, contracts that it shall be so, and that this contract is made with the highest bona fide bidder. And in case of a breach of it, that he has a right of action against the auctioneer. This is also a comment that was passed by Giopu in his book Contract Law 13th edition on page 30. This is how he commented on the case of Wallow and Harrison. There were two agreements. First, there was a bilateral sale agreement determining the purchaser of the goods. In this context, the plaintiff's bid was an offer. But since his bid was not accepted, he was not entitled to the horse that was knocked down to the owner. However, there was a second agreement. Since the advertisement of an auction sale without reserve is a unilateral offer by the auctioneer that no reserve will be applied, Martin B indicates that the highest bona fide bidder can accept this unilateral offer. So all we are saying over here is that when you advertise your sale without reserve price, then you are saying that you shall sell it to whoever shall be the highest bidder. And so whoever shall make the highest bid will be deemed to have accepted your offer that you made. And you cannot refuse to sell to that particular person. So auction sales without reserve, bear in mind that once you enter into a contract, once you enter into an auction sale and say it's without reserve, then it means that you must sell to whoever shall be the highest bona fide bidder. And remember what Pools of Geopol is saying, that it means that when you say it is without reserve, you are making an offer to whoever shall be the highest bid. So whoever shall be the highest bid will be deemed to have accepted your offer, and you have to sell to that particular person. And I'm highlighting on this case because you remember when we did the case of Harrison and Nickerson, we mentioned that generally an invitation to make bid at an auction is an invitation to treat and not an offer. You must draw the distinction between Harrison and Nickerson and the case of Wallow versus Harrison. That's auction sales without reserve price. Now let's go to auction sales subject to a reserve price. Auction sales subject to a reserve price. Now, while an auction sale is described as one which is subject to a reserve price, then note the following. Please never confuse the two. Take note of the following when the auction sale is declared as subject to a reserve price. 1, it means that a specific price has been fixed, which is a reserve price, and the vendor will not sell the goods below the said reserve price. If a specific price has been fixed, which is the reserve price, the vendor will not sell the goods below the reserve price. So if it's a house and the reserve price is $100 million, it means that whatever bid that you make, if it's below the reserve price, then the vendor is not obliged to accept it. He will not accept it. So if you have a car and you want anything more than $100,000, say that the reserve price for this vehicle is $100,000. That means that any bid a person makes that is below that one, you are not bound to accept it. So take note, where an auction sale is described as subject to a reserve price, the following shall apply. 1, it means that a specific price has been fixed, which is a reserve price, and the vendor will not sell the goods below the said reserve price. Number 2, the vendor can bid only once, which is at the beginning of the auction, before any other bid is made. The auctioneer shall not be under any obligation to sell the auction goods to the highest bona fide bidder, so long as the bid is below the stated reserve price. You see, it means that if the sale is subject to a reserve price, if you are the highest bona fide bidder, insofar as the bid is below the stated reserve price, the auctioneer is not bound to sell it to you. So you see how you can contrast this with the case of Wallow and Harrison. Wallow and Harrison says that if it's without reserve price, you sell to whoever makes the highest bid. And the owner cannot make a bid because he will not be in good faith. That's Wallow and Harrison. But when you come to auction sales with a reserve price, the auctioneer can only accept bids that are above the reserve price. And the vendor can only bid once at the beginning. That may be the reserve price. After that one, any other bid can be made. If the bids are made and they are below the reserve price, the auctioneer is not bound to accept it. So auction sales without reserve price, you sell to whoever is the highest bidder. But with reserve price, that one, if you're the highest bidder and your bid is below the reserve price, you're not bound to sell to you. And so that is what you see in Ghana. You see it under section 17.1 of the Auction Sales Law 1989, PNDS Law 230. Is a very, very important legislation. Section 17, subsection 1 of the Auction Sales Law 1989, PNDS Law 230. This is what it says. The auctioneer shall state the particulars or conditions of sale by auction of any goods or land, whether the sale is without reserve or subject to a reserve price, and whether a right to bid is reserved by the vendor. It means that when you are going to sell anything by auction, auctioneer indicates, is it subject to reserve price or without reserve price, so that we will know as bidders how we will go about our bidding. So the law mandates that the auctioneer must state that this sale is subject to a reserve price or without reserve price. Then section 17, section 4 is one of my favorite sections in the Auction Sales Law 1989, PNDS Law 230. Section 17, section 4. Where the sale is subject to a reserve price as regards any one or more specified lots, it shall be lawful for the vendor or any other person employed by him to give one bid for each lot and no more. You see, where the sale is subject to a reserve price as regards any one or more specified lots, it shall be lawful for the vendor or any person employed by him to give one bid for each lot and no more. And such bid shall be openly declared at the auction upon the lot being put up for sale before any other bidding for such lots is received. So if it is reserve price, the vendor, you can bid once, and that bid will be declared at the auction, meaning that you declared your reserve price. Then nobody will now be, nobody's bid that is below that one may be accepted. Then the most important provision in the auction sales law, if you forget any section at all, this one won't have to forget it. It is section 17, subsection 7 of the Auction Sales Law of 1989, PNDS Law 230. You must not forget this one. If you forget any provision under the Auction Sales Law. Section 17, subsection 7. And I quote, where the sale is subject to a reserve price, the sale shall not take effect even when the property is knocked down to the highest bidder, if the highest bid is lower than the reserve price. And in such a case, the highest bidder has no right of action. Provided that where an auctioneer signs a memorandum of contract after accepting a bid below the reserve price, he thereby impliedly warrants that he has authority to sell at the price named and is liable to the purchaser for breach of warranty of authority. Meaning that where the sale is subject to a reserve price, the sale shall not take effect even when the property is knocked down to the highest bidder, if the highest bid is lower than the reserve price. So if by mistake the reserve price is $1 million and you make a bid of $500,000 and the auctioneer by mistake knocks it down to you, the law is saying that where the sale is subject to a reserve price, The sale shall not take effect. The sale shall not take effect. It shall not take effect even when the property is knocked down to the highest bidder. If the highest bid is lower than the reserve price. So if the reserve price is $1 million and by mistake it is knocked down to you, and you are not paid the $1 million, then it's not bound, they're not bound to sell it to you. And you can't sue and compel them. But where the auctioneer goes to sign a memorandum saying that, you know what, the reserve price is $1 million, but the vendor says I can sell it to you at $20,000. That one, he's warranting that he has an authority to sell to you at that price. So if it turns out that he doesn't have the authority, you can sue the auctioneer for breach of warranty of authority. But the general rule is that where the sale is subject to a reserve price, the sale shall not take effect even when the property is knocked down to the highest bidder, if the highest bid is lower than the reserve price. And then also very, very important is that when you come to auction sales without reserve price, take a look at section 17(3) of the Auction Sales Law 1989, PNS Law 230. You remember auction sales without reserve price, where we said that you contract to sell to the highest bidder and that the owner cannot make a bid. So if your house is being sold at auction without reserve price, if I make a bid of 1 Ghana cedi, you are bound to sell to me. You remember we said that? And we look at the case of Wallow and Harrison. Look at what the Ghanaian auction sales law says about auction sales without reserve price. It says that where the sale is without a reserve price, it shall not be lawful for the vendor or any person acting on his behalf or employed by him to bid at such sale, or for the auctioneer knowingly to take any such bidding. You remember what happened in Wallow and Harrison? When Wallow and Harrison, the fact where the plaintiff made a bid of 60 guineas, it was sold without reserve price. Then the owner came to make 61. Then they gave it to the owner. You remember the court held that, my friend, as an owner, if it is sold without reserve price, you cannot make a bid. And the court rather made them give the item to the highest bona fide bidder, who was the plaintiff who bid the 60 guineas. You remember Wallow and Harrison? Now, our auction sales law is saying that where the sale is without reserve price, this is a statute, it's a statute passed in Ghana. So it's given parliamentary force. That where the sale is without a reserve price, it shall not be lawful for the vendor or any person acting on his behalf or employed by him to bid at such sale, or for the auctioneer to knowingly take any such bidding. You see, so if it's without reserve price, as for the owner, we have taken you out. Section 17(3) of the auction sale, we are taking you out. You can't make any bid if it's without reserve price. And look at section 17(6) of the auction sales law, that where the vendor or any person acting on his behalf or employed by him bids at any such sale, contrary to any of the provisions of this section, any purchaser may refuse to fulfill his purchase, but the highest bona fide bidder shall be entitled, if he so elects, to have the goods or land offered to him. So if you, the vendor, it is without reserve price, and you go and make a bid, me, the one who is the highest bona fide bidder, I can bring an action to compel that I am the one who should be given the particular item. So take note of the auction sales with reserve price and the one without reserve price. With reserve price, the owner can bid once, only once. But without reserve price, owner, we are not even allowed to make any bid at all, because the rule is that they are selling to the highest bona fide bidder. And then, remember when you're looking at, so as far as our invitation to treat is concerned, we have dealt with display of goods, we've dealt with auction sales, we've dealt with tender notices, we've dealt with advertisement of goods, we have dealt with circulation of catalogs or price lists. Circulation of catalogs or price lists. What is the rule? The general rule is that circulation of a price list or catalogs advertising goods for sale shall constitute an invitation to induce persons to make offers, i.e., invitation to treat, and therefore the circulation of the price list cannot be an offer in itself. So if it is Christmas, you see Malcolm circulating price list of this item for this amount, microwave 500 cedis, 300 cedis. If you travel and you get there, and they say the microwave is now 1,005 cedis, you can't do fuku about it because the circulation of price lists or catalogs only amounts to an invitation to treat and not a contractual offer. It is when you go there and you get make your offer. But the circulation of the price list itself is not an offer. It's only an invitation to treat. So when you get there and the price has changed, you can't complain because no offer is made to you. That is what we mean by circulation of price lists amounts to an invitation to treat and not an offer. And the authority for that is Grenga. Grenga is called G-R-A-I-N-G-E-R. Grenga and Son versus Golf. Golf is G-O-U-G-H. 1896, appeals cases as page 325. And this is what was held in that case. I'm quoting the dictum of Lord Herschel, and I quote as follows. The transmission of such a price list does not amount to an offer to supply an unlimited quantity of the wine described at the price named. Again, the transmission of such a price list does not amount to an offer to supply an unlimited quantity of wine described at the price named, so that as soon as an order is given, there is a binding contract to supply the quantity. If it were so, the merchant might find himself involved in a number of contractual obligations to supply wine of a particular description, which he would be quite unable to carry out. His stock of wine of that description might necessarily be limited. End of quote. So we've seen in this case of Grenga and Son versus Golf that transmission of a price list does not amount to an offer, but it's rather an invitation to treat. So if Malcolm, Game, Palace Mall circulates price lists of items that's only for Christmas, Samsung, the circulation of price lists is not an offer, but it's rather an invitation to treat. So when you get there and you see the circulation of price lists at 500 cities, and you get there and it's 1,000 cities, just pack your things and go. Don't go and complain I'm going to sue them, because the circulation of price lists amounts to an invitation to treat and it's not an offer. So it's when you go there, you go make the offer, which they may or they may not accept. So in this lecture, by way of recap, what we have sought to do is to explain the different forms of invitation to treat you can have. We have dealt with display of goods in a shop. When I said display of goods in a shop will not amount to an offer, but would amount to an invitation to treat. When we look at Fisher and Bell and Pharmaceutical Society of Great Britain versus Booth Cash Chemists. Then we dealt with advertisement of goods in a newspaper. And over there, we look at the case of Patrick and Crittenden, where we're told that the advertisement of the bed was not an offer, but rather an invitation to treat. But remember our caution that even though we've been told in Patrick and Crittenden that an advertisement is only an invitation to treat, remember the case of Carlyle and Carbonic Smoke Ball Company Limited, where we're told that the advertisement was construed to be an offer. And we saw a similar thing in the case of Lefkowitz versus Great Minneapolis Surplus Stores. And then we also dealt with tender notices. And remember, for tender, we said the general rule was that an invitation to sell goods by tender would only be deemed to be an invitation to treat and not an offer. But, and over there, we look at the case of Spencer and Harding. But we gave a caution. But when the invitation to sell by tender is accompanied by express words that you shall sell to the highest bidder, for that one, you must sell to the person who becomes the highest bidder. And over there, we look at the case of Havela. Havela Investments Limited versus Royal Trust Company of Canada Limited. That was for tender notices. Look at Spencer and Harding and then Havela. Then we also dealt with auction sales. And over there, we have to do a distinction between auction sales without reserve price and auction sales with reserve price. So auction sales without reserve price, over there we're told that you mean that you must sell to whoever shall be the highest bidder. Whoever shall be the highest bidder. Remember, for auction sales, if it is without reserve, but if it's with reserve price, it means that you cannot sell below the reserve price. But remember the general rule that we saw in Harrison versus Nickerson, that generally auction sales are invitation to treat and they're not offers. That's why the person who traveled from far and went there and the thing had been withdrawn, he couldn't do anything about it because the invitation to bid at the auction was only an invitation to treat and not an offer made to that particular person. So look at the general rule under Harrison and Nickerson that an invitation to sell goods by auction is an invitation to treat and not an offer. And we draw a distinction. We drew a distinction between auction sales with reserve price and without reserve price. For without reserve price, we look at the case of Harrison. We look at Wallow and Harrison. Without reserve price, look at Wallow and Harrison, where we are told that if it's without reserve price, the owner cannot bid, that they must sell to whoever is the highest bona fide bidder. That's without reserve price. But if it's reserve price, it means that they cannot sell below the reserve price. And remember the provisions we look at in our auction sales law. And then finally, we wrap up with circulation of catalogs or price lists, where we are told that if you circulate price lists or catalogs, they would only amount to an invitation to treat and not a contractual offer. This is where we shall wrap up with our discussion on the different forms of invitation to treat. In our next lecture, we shall continue with the discussion on what will then amount to an acceptance. This is where we shall wrap up with our lecture. Thank you.